What I have for you today is an interesting question about the definition of royalties under the German-Spanish treaty in a case called Nintendo Iberica. So here you can see it is a decision from the Spanish Supreme Court, and it is in appeal to the 2020 decision of the Spanish National Court. We will also look at the decision from the National Court on our way. So the structure Nintendo of Europe GmbH, a German company, bought IP from Concentra Productos para Crianças, I assume, which is concentrate products for kids, in Portugal, and transferred that IP to Nintendo Iberica SA. So we had this chain of transactions. The price was 1.8 million, which is the exact same price as what Nintendo Europe paid to Concentra Productos. And then Nintendo Iberica set up a PE in Portugal. So what happened was Concentra was first a distributor for Nintendo, a third party. Then I guess sales grew too much and Nintendo had to pay Concentra too much money. So they decided to rather bring it in-house and have Nintendo Iberica run a Portuguese permanent establishment and do the sales from there. And obviously they wanted client lists and stuff like that. So if we look at what was transferred, this is just a copy from a commercial website, which also explained that in 2009, Nintendo Iberica expanded its commercial operations to Portugal through a new office in Lisbon. And then the question was, in this case, whether the payment from Spain to Germany was subject to a royalty withholding tax. And if we look at what was transferred, I will give you the text here, but a caveat first. Especially English, Spanish, it seems like neither DeepL nor Google are very good with translating very accurately, and it's exasperated, especially in the case of the Spanish Supreme Court, by the court using an incredible amount of intermittent phrases during its sentences, having very long sentences with lots of comments in between, almost like you do when you speak, not when you write. Which is why I also quote more from the National Court, because the sentences translate a little more legible. So the National Court described the case as follows. In the present case, the contract of March 24, 2009 in Expository C refers to the acquisition of certain customer data and operational data of Concentra. And then they say the object of the agreement consists of the transmission of certain customer data and operational data. Customer data means data maintained by or on behalf of Concentra per 2009 relating to any of Concentra's customers for Nintendo product in Portugal, including, and I assume they address Concentra, your name, your primary business address, and if different, your billing address, the addresses of all your retail stores, your billing for the past 3 years, your credit history, and any other relevant information. And then operational data means any data maintained by Concentra or on behalf of Concentra, so it's wide, which were relevant to the provision of its distribution and shipping services in Portugal in relation to Nintendo products, including for each customer, their delivery, I assume their addresses, the transportation, the EDI, which is I think it's the distribution interface, the electronic distribution interface, and personalization requirements. So what kind of machine and television and computer they used is EDI, I think, but I'm not 100% sure. And then the court goes on to say, although it can be accepted that the various data transferred could be found in public databases, what explains their high commercial value is precisely their confidential and what nature and what is not accessible to others, since the data is related to Nintendo customers and only the Portuguese entity, Concentra, that originally provided the aforementioned data is aware of its customers, precisely due to the specific commercial relationship. That is what allows one to talk about royalties in this case. So what the court here says is, you know, this was not some general public data. This was very specific, confidential customer data held by Concentra and transferred through Germany, ultimately to Spain. And the court then says the object of the transmission, therefore, unequivocally meets the characteristics of theoretical, practical knowledge, know-how, or information relating to commercial experiences referred to in Article 12 of the double tax agreement. So it was very much a question, this one-time payment, if I understand it correctly, made between Germany and Spain. Was this subject to a capital gains tax, in which case Spain could not tax, or was this subject to a royalty withholding tax, right? And then the court comes up with a very interesting theory, and it says the express intention of the parties to sell and correlatively buy operative data, confidential financial information, or customer data does not mean that the income generated loses the nature of royalties. It says it must be remembered that the settled jurisprudence considers the sale of know-how. The TS affirms that income generated is a fee of ownership where such knowledge is transmitted. But here it comes. Since the TS considers that the transfer of property cannot be granted when legal possession cannot be guaranteed, which cannot be done with confidential data, techniques, or information, in this case, the alleged seller does not dispose of what is sold, but rather shares it with the alleged buyer, thus rejecting the possible existence of a capital gain not taxed in Spain. So what the court says here is, when you transfer something, you don't have anything left of that. That is a sale, right? But when you transfer know-how, you cannot delete your own memory, and therefore you still have that know-how, and therefore you cannot be said to have sold the know-how, and therefore there cannot be a capital gain under Article 13 of the treaty, because what you basically did is you shared the know-how, right? And therefore Spain can tax or levy a withholding tax. And the taxpayer appeals against this, and it asks the Supreme Court that the Honourable Chamber sets the following interpretive criteria to the tax classification of the full transfer of know-how in Article 12 and 13 of the double tax treaty between Spain and Germany. That the transfer of full ownership of know-how is considered a capital gain subject to taxation exclusively in Germany. So this is what the taxpayer asked in their appeal to the Supreme Court. Now this case was on shaky grounds from the very first day, because it is settled Spanish Supreme Court doctrine that intangibles basically cannot be transferred because you cannot guarantee the undisturbed legal ownership of this data. But let's see how the Supreme Court deals with it, right? The Supreme Court says the most authoritative doctrine rejects the validity for tax purposes of a full transfer of property when the legal and peaceful possession of the things sold cannot be guaranteed, as is the case here with secret data or formulas, right? If there is no transfer, there is no capital gain. It is essential that the seller completely lose ownership of the thing or right sold, and that is practically impossible in the transfer of data in virtual supports it, right? So the Supreme Court says you cannot transfer it, therefore no capital gain. And then it looks also to the treaties, right? So the treaty applicable at the time was a 1966 treaty, and Article 12.1 said, obviously the resident state can tax, but then Article 12.2 says, however, such royalty may be taxed in the contracting state in which they arise. In other words, we assume in this case in Spain, because that's where the payor is, right? And according to the laws of that state, but the tax so charged shall not exceed 5% of the gross amount of the royalties. And now if we look at the definition of royalties under the 1966 treaties, it is pretty OECD compliant from the 63 model onwards, because it says the term royalties means payments of any kind, so wide wording, received as a consideration for information concerning commercial experience. I'm summarizing it here, but if you read the text word for word, you see that's what it comes down to. There is also a later treaty from 2011, but since the transaction happened in 2009, the court rightly said, no, we're applying the 2009 treaty, not the 2011 treaty, right? Interestingly, also, there is no royalty withholding tax in the 2011 treaty, so that would not have helped the taxpayer. Now, if we look at the OECD commentaries, because they're part of what the taxpayer complained about is said that the court interpreted the OECD or the German-Spanish treaty dynamically, and it seems to be quite a hot issue in Spain. Quite frankly, I don't quite understand it, because I don't think Spain is any different than most OECD countries. I would say that if a country does not interpret a treaty dynamically, then you get into the whole discussion. You can also see this in the introduction to the OECD moral commentaries, that they say, you know, when we sign the treaty, those are the commentaries that apply. Later commentaries cannot apply, right? It doesn't mean that you've got to change the text before you cannot change cannot apply the commentaries of the treaty. And the OECD even goes as far as saying, you know, even if the text is changed, but it basically says the same as what the previous text said, it just writes it a little clearer, then you can still apply the later commentaries, right? Now there are commentators. Ian Y was one, Uriel Menendez in another case from 2020, which says that the court rejects the dynamic interpretation of the treaties, and that must be within the Spanish context, because the court very much accepts the later commentaries, as we will see right now. So the court starts by saying in paragraph 4, it is not true that a problem of dynamic interpretation of the convention has arisen, because this is what the taxpayer has been complaining about. Since the inspection resorted to the wording of the commentaries of 1966 and to the previous comments and the closest to the operation to be analyzed, which were those of 2008. And if you look at the 1963 commentaries, it is very short and doesn't say a lot about what we're going to discuss. It had Article 12, and it had a commentary, a definition of royalties, which largely matches or more or less exactly matches the 1966 German-Spanish treaty. But nonetheless, the court refers, and the Supreme Court refers, to 2008 commentaries, right? And the Supreme Court says the applicable commentaries of the OECD model, whose interpretive value has already been recognized by this chamber, would be those of 2008. Right? It's not true that the tax inspector applied the 2012 commentaries just because the assessment was made in 2012. The fact that they are not a source of law, the court says, does not mean that they cannot help the judge. So Spain, very much to their credit, recognize the value of the OECD commentaries in interpreting their treaties. Now, if we look at the 1966 treaty and the definition of royalties, it says the term royalties means payments of any kind received as a consideration for information concerning commercial experience, right? And then if you look at the 2008 Border Convention, you can see the Article 8 is slightly different, but not much. It's a resident state can tax. It does not have a source taxation, because the OECD doctrine is not to allow source taxation for royalties, only for dividends and interest. And then the definition for royalties, more or less word for word, is the same, except for this red piece on the 66 treaty, which was taken out, but doesn't significantly change the meaning of the treaty, right? It still talks about consideration of any kind received as payment of any kind or received as consideration for information concerning commercial experience. So at the face of it, one could say that, you know, the 2008 commentaries can be applied to the interpretation of the 66 treaty. One question that I have, and I will raise it in the end again, is, you know, can you use the Model Tax Convention definition on royalties when there is no withholding tax in the OECD Model Convention? You know, are these articles not by definition incomparable? Because if one treaty article allows withholding tax and the other one doesn't, who is to say that the definition of royalties in both those articles must be exactly the same? Surely the fact that the one has withholding tax and the other one does not makes such a big difference that one can argue, well, if the other one also had a withholding tax on royalties, maybe they would have changed the definition of royalties, right? So the court doesn't address this, but I think it is a worthwhile question to ask. But the court goes on to talk. Now we're talking about the Supreme Court on the OECD commentary. If we look at what the OECD commentary says in Article 11, paragraph 11.3, the need to distinguish payments for the supply of know-how and the payments for provision of services, which also would have meant there was no withholding tax to Germany, sometimes give rise to practical difficulties, right? And the court refers to this and make use of this. And in most cases, paragraph 3 says, involving the supply of know-how, there would generally be very little more which needs to be done by the supplier other than to supply the existing information. On the other hand, a contract for the performance of services would involve a very much greater level of expenditure by the supplier. And that is true. If you have know-how, you already know it. Otherwise, you wouldn't know how. So when you transfer that, you simply give them what you know, right? Whereas if you were to provide a service, you basically have to go and develop that know-how yourself and then transfer it, right? And the OECD says, well, that is a service because you're developing the know-how. But if you have the know-how, you give it. That is not a service. That falls under the ambit of Article 12. And 11.4 is even more telling because it says examples of payments not to be considered as consideration for know-how, but rather for services include, interestingly, it says payments for lists of potential customers out of generally available information. But then the commentary goes on to say, in brackets, a payment for the confidential list of customers to which the payee has provided a particular product or service would, however, constitute a payment for know-how, as it would relate to the commercial experience, right? So then you would not have a service, you would have a payment for know-how. And this is basically what the Supreme Court also says. This is the payment for this last case, the confidential customer list, fits in Article 12 of the Hispano-German Agreement of 5 December 1966. The list of clients is of confidential or restricted nature, so that what is paid is precisely the access to that restricted or confidential information. And that is basically the taxpayer loses at this case. I think there are a couple of interesting further comments to make. One is this case reminds one very much, or it reminds me of the Pierre Boulez case, which is from 1984. It's a US case, and for those who do not know or do not remember, Pierre Boulez was a French orchestra conductor living in Germany and got paid by a UK company, EMI, to conduct a New York Philharmonic Orchestra in the US. They then made records, long-playing records from those recordings. All the IP rights belonged to EMI, not to Boulez, and Boulez was paid a royalty. It was literally called a royalty in the contract based on the number of sales of the records. Germany said this is royalty. The US-German treaty says that only Germany can tax, whereas the US says this cannot be a royalty, because in order for a payment to be a royalty, you must have the underlying intellectual property rights. And clearly, the contract says that EMI has the underlying property rights, not Boulez. Therefore, this must be a payment for a service or for Boulez being an artiste, and therefore the US can tax. Now, again, the core issue was the definition of royalties, right? So very different facts, very different circumstances, but same problem. And again, we've also talked about, can the court use the OECD commentary definition if Article 12 of the OECD does not allow withholding tax and the German-Spanish treaty does? I think it potentially makes these articles incomparable, not definitely, but I think you need to at least address the issue. And that brings us to the Vienna Convention on Law of Treaties. And the question is, would that have helped? Because if you look at the plain meaning of the text, as the VCLT says that you must, royalties mean payments for the information concerning commercial experience. And that is exactly what Nintendo Iberica paid for. So maybe you didn't even need to go to any treaty interpretation. You could simply follow the VCLT and say Spain can tax, right? Does the court even need the doctrine of lack of certainty of undistributed legal possession? I think what makes this case special is this strange notion of the court. At least I'm calling it strange because the first time I come across something like this, where the court says, if I transfer something confidential to you, I still have that confidential information. So I cannot transfer it. I can at most share it with you, and therefore it can never be the payment that I receive for capital gain. I mean, the question is, looking at the text of Article 12 and the VCLT and everything that we mentioned so far, do you even need this doctrine, right? And I think the other interesting question, especially from a Spanish perspective, is lots of companies are out there selling customer data, right? Facebook does it all the time. LinkedIn does it. I mean, this is the big problem why with privacy and EU rules and US multinationals. And the question is whether every payment made by a Spanish resident for information about other Spanish residents potentially qualify for withholding tax on royalties, either because there's no treaty or because there's a double tax treaty which allows for withholding tax on royalties. Anyone that knows the answer to this question, please feel free to post in the comments. And then a mere curiosity, Concentra was specifically paid this 1.8 million euros. I assume that was a final payment also for this list of customers. Now one wonders, is there a specific Portuguese or German reason, or maybe even a Spanish reason, why this was called payment for a list of customers and know-how instead of just goodwill? Because after all, Concentra was the distributor for Nintendo until 2009. I do not know. And then, considering the fact that the customer list was used for Nintendo Iberica's PE in Portugal, one would assume that the payment for this IP would also be allocated to the PE in Portugal. And if the payment is allocated to the PE in Portugal, the question is whether it would even be deducted or deductible in Spain. And then that raises the other question of, whether it is not Portugal who should instead levy a withholding tax on the payment for the IP, which incidentally under the German-Portuguese treaty, as far as I'm aware, would have been 10%, not 5%, instead of Spain. Now, when it comes to sourcing of royalties and who's entitled to levy withholding tax and who's entitled to who's obliged to give relief of double tax, I find the OECD commentaries difficult to follow. So again, any comments below would be welcome. And then just the last point. The National Court actually had two other issues to address. The first one was the following question discusses the admission of the 5% withholding tax practice without paying attention to the expenses obtained by the taxpayer. So here what the court says is, Germany had to pay Concentra the same amount as what Spain paid Germany. Therefore, Germany made no income, but is still paying a 5% tax on the gross amount received from Spain. And is that allowed under EU law? And the court, the National Court said, well, first of all, there's no TP issue here, right? Because clearly the payment made from Spain to Germany was then a third-party price, or it was a perfect cup, if you want. But the EU question about whether this is discriminatory to tax the German company on gross income, whereas the Spanish national would have been taxed on net income, is never referred to the court, because the court basically says, these are not comparable situations. I think the court went a little easy over it, but I'm not so up to date with EU law that I can give a definitive expression about that. And then just finally, the Supreme Court says the appeal filed by the Attorney Mr. Arak Almendros on behalf of Nintendo Iberica has not been granted. So Nintendo lost the case. I hope you enjoyed this case. I think it is a rather interesting interpretation and application of what is a royalty and what is not. And I look forward to discussing the next case with you next week. Bye for now.